Think about the family home. For many of us, it's not just a house, it's where memories are made. It's the biggest asset most families will ever own. But what happens when a loved one passes away and that home needs to be transferred to the next generation? For decades in California, this process has been a major source of stress, expense, and delay. Even for modest homes, it often meant getting trapped in a long, expensive legal process called probate. The old rules were completely out of touch with today's real estate market. The threshold to avoid probate was so low that nearly every home in California, from a city condo to a suburban house, was automatically funneled into a long, public, and expensive court process. But that is all about to change. Starting April 1st, 2025, a new law, California's AB 2016, is going to be a game changer for countless families. It's designed to provide a new pathway for transferring the family home without the time and cost of a full probate. So, let's get right into the details. If you own a home in California, or if you're expecting to inherit one, this is information you need to hear. First, let's look at the old and new rules side by side. Old law. The small estate threshold was around $185 to $500. If your total estate, including the value of your home, exceeded this, you had to go through full probate. This was the problem. In California's real estate market, a home's value, even if it was a small one, almost always pushed an estate over this limit. This forced families into a legal process that could last a year or more and cost tens of thousands of dollars in legal fees. Now for the good news. AB 2016 creates a separate new pathway specifically for the family home. New law, AB 2016, the primary residence exemption. If the decedent's primary home is valued at up to $750,000, it can now be transferred using a streamlined process. This is the biggest change. You no longer have to count the home's value against the old small estate limit. Streamlined process. The new method is called a petition to determine succession to real property. It involves less court involvement, which means less time and less cost. Other assets. The old small estate limit for other assets like bank accounts and vehicles is also increasing from $184,500 to $208,850. These two thresholds work independently. This means an estate could have a primary residence worth $700,000 and non-real estate assets up to $208,850 and still qualify for a simplified process for both. Who does this law apply to? There are two critical conditions to qualify for this new streamlined process. It must be the decedent's primary residence. This law does not apply to vacation homes, rental properties, or any other real estate. The death must occur on or after April 1st, 2025. If the death happened before that date, the old rules still apply, regardless of when you start the probate process. The practical impact of this law is enormous. It's a direct response to California's housing market and is designed to provide relief for middle-class families. It means many more people can now avoid the most burdensome parts of probate when they inherit a family home, which can preserve family wealth and reduce unnecessary heartache. It's a big step forward, but it's important to remember that this law doesn't eliminate the need for proactive estate planning. A properly funded living trust is still the gold standard for avoiding probate entirely for all of your assets, not just your primary home. This new law is a great safety net, but it's not a substitute for a comprehensive plan. If you have questions about how this law affects your family, it's always a good idea to reach out to my team at Princeton Pacific Properties. We'll get you connected to the right estate planning attorney.